Hi everyone, excuse me, it's Rob Ryder. And today we're going to talk about masters at common law and financial forensics. This mainly has to do, for this particular moment in time, with your mortgage for a house, which really, the mortgage isn't tied to the house other than you put the house up for collateral, or so it says, right? The mortgage or the deed of trust is its own contract, and the warranty deed is its own contract. Without getting too complicated, if you were to look at both of those documents, you would see that your proper person name is never used. What they did is they created a legal fiction. So it could be something like Robert A. and Kimberly A. Rutluski, husband and wife. Right? That could be what you see on your warranty deed and say, yeah, it's a legal fiction. That represents something. And you are one of the things it represents, or one of the people it represents, but it represents other people also, and those other people would be the ones who are actually holding the legal title, because when you read your warranty deed, it says you are a tenant. Where's the legal title? If you had the legal title, you wouldn't be a tenant, you would have the title in fee simple. Well, that's what your insurance says. They're going to guarantee your title in fee simple. That's all the land, the house stuff, right? Now, forgetting that for just a second, go to the deed of trust or the mortgage and look at it, and the borrower will be names somehow put together to create a legal fiction. And so again, you're not the borrower on the piece of paper as it shows. That's an entity that's been created, right? It's a legal fiction. But you are a party of interest to it. In fact, you're its creditor. And so we're going to see how that fits in, and how, knowing these things, if we go to the right people who know something about financial forensics and say, well, that's my property, how do I claim it? And maybe they can tell us, because they've left a lot of bread trails for us to follow, breadcrumbs. So we're going to look at some of them and see if we can put it together. I don't know how to do this. I don't have any property, right? I'm just reading what I read and say, well, shit, somebody ought to go try this. And there's detractors of mine that say I don't ever do any of my own stuff. Well, I don't have any property, so I can't do this, right? And so, hey, I do the things I can, and the things I can't, I just talk about. But if you have property, you may want to go try this. And this is why. So, masters at common law and financial forensics. Well, what is a master at common law? An officer of the superior courts of law who has authority for taking affidavits sworn in court and administering a variety of oaths, also empowered to compute principal and interest on bills of exchange and other engagements on which suit has been brought. He has the power of an examiner of witnesses going abroad, and the like. Okay, well, who computes principal and interest? Right? That's an accountant. It's not an attorney at law. It's not a judge. That's accountant work. And sure enough, masters aren't in the, as we'll see, masters are in the Court of Chancery. They're not in the Court of Common Pleas, which is the court of law, right? Where the Court of Chancery is a court of equity. As is the Court of Exchequer, which, guess what, also has masters. Forensic accounting. Now about forensic accounting. Forensic accountancy and financial forensics is a specialty practice area of accounting that describes engagements that will result from actual or anticipated disputes or litigation. Forensics means suitable for use in a court of law. Excellent. And it is to that standard and potential outcome that forensic accountants generally have to work. Forensic accountants, also refer to forensic auditors or investigative auditors, often have to give expert advice at the eventual trial. Okay, so there's people that can look at your paperwork and say, hey, this is what's actually going on, bean counters, and put it together, suitable for use in a court of law. Well, we just needed to figure out what it is we want them to tell us then, because, you get what you ask for. Maybe if we asked them for something a little bit different than we have been, they could provide it. And it will be much more better explained when we actually look at what they have said. But for today, it's Wednesday, August 24th, 2016. And yes, I'm asking again, if you can donate, please, I need you to do it. My PayPal account is ashleyrytlewski@gmail.com. That's ASHLEYRYTLEWSKI@gmail.com. Or you can mail it to me, snail mail, Robert Allen Rytlewski at 10955 14 Mile Road Northeast, Oakfield Township, Michigan, 49341. My email address is courtofrecord@aol.com. If you decided you wanted to do it by credit card, you could email me there. You can email me anyways, or you can call me. I got nothing to hide. I mean, I'm not in it for the money. I just need money to live so I can do this. When I get it figured out, I'll go get my own money. I'm just trying to find a string to grab a hold of to say, somebody, let's go pull on this and see what we can find. So, a little bit more on masters. So, masters in chancery, an officer of the Court of Chancery. Well, there you are. The origins of these officers is thus accounted for. The chancellor, from the first, found it necessary to have a number of clerks, were for no other purpose than to perform the mechanical part of the business, the writing. Somebody had to write up the writs. These soon rose to the number of 12. In process of time, this number being found insufficient, the clerks contrived to have other clerks under them, and then the original clerks, the 12, became distinguished by the name Masters in Chancery. He is an assistant to the Chancellor who refers to him interlocutory orders for stating accounts, computing damages, and the like. Masters in Chancery are also invested with the powers by local regulations. Okay, so they're on the Court of Chancery. Yes, there is. See, it's called the Court of Chancery. And the Court of Chancery is different than the Court of Common Pleas, and it's different than the Court of Exchequer, and it's different than the King's Bench. So in English common law, in the Court of Common Pleas, all they cared about is he who holds the title is the owner. If somebody had a title to a piece of property, forgetting there's anybody's names on it, this is the title to the land. As far as the court's concerned, they're the owner. And they don't care if they got it by fraud. Well, that's the court we're going into. We're going into a court of law that really only cares, well, who has the title? If you don't have the title, you're not the owner. Well, we can't use that. We need to go to a court of chancery. Because chancery is where it was determined if the deed that somebody said they had was gotten by fraud. It's a different jurisdiction. And they don't use attorneys at law. They use masters in chancery. Got to find a master. In England, there are two kinds of masters in chancery, the ordinary and the extraordinary. The masters in ordinary execute the orders of the court upon reference made to them and certify in writing in what manner they have executed such orders. And so that's what forensic auditors do. If the court hands down a verdict that says you're the winner and you can go collect your debt that's owed you, they don't do it for you. You have to get it done. And so these masters are the ones that could execute the orders of the court to get your property. And when I was watching a video on these forensic examiners, they had talked about that being one of the things that they did. Masters extraordinary perform the duty of taking affidavits, touching in any manner in or relating to a court of chancery, taking the acknowledgments of deeds to be enrolled in the court, and taking such recognizance as may by the tenor of the order for entering them be taken before master extraordinary. And I think that's what they call a special master, which can be appointed by the court to a court case. And really that's what we need, because what we're talking about, well, that's if you're going to be in the court. I'm trying not to go to court. But if you're in court already, well, hell, you want a master, because this is all about the money. Who owns them beans? And so we're going to see how that, how we're going to use that, hopefully, to our advantage. And so, let's go to, where do I want to go? Go here first. And so, here's a for instance. MDD, Forensic Accountants. This is the lady that's in Detroit. And if you look behind her name, it says CPA-CFF. Well, CFF stands for Certified in Financial forensics, which comes from the American Institute of CPAs, who you take a bunch of things, you get to be one of these, hang those letters behind your name after CPA. They're already CPAs. Now they're going to be a CPA and a CFF. And that's what Susan is. And so what they can do, just quickly go through this manual. So this is a manual that you could download. You could download this from this site. I just don't remember exactly where it is. Or if you go to Certified Financial Forensics on Wikipedia, Certified in Financial Forensics in Wikipedia, and you go down to the bottom of this thing and click this external link, boom, that's how I got this. This thing will pop up. And in here, it talks about what they have to do to get this designation. And just one thing. So CPA professional responsibilities in civil and criminal matters, ethical issues, liability issues, roles, expert witness, consultant, other. What's the other? They could be a referee mediator, an arbitrator, or a special master. So if they're talking about a master, an arbitrator, or a referee, they're talking about somebody who should be a CPA. That's what we want to use. And so I'm not going to spend any time looking at this. That just lists all the different things they learn and what they know and do. What I really want to do is, because it's a bit to read, is let's get it on and get it decided. So what I'm going to read here is this, I call it the testimony of John Corman. John Corman was in Boca Raton, Florida. And he wrote a letter and addressed it to the Attorney General of each of the states of America. And I found this on this dude's site, Living Lies Garfield Firm, under the heading, so you may want to write this down so you can just Google this and it would take you to it. Borrower is actually entering into an undisclosed investment contract, not a loan. Borrower is actually entering into an undisclosed investment contract, not a loan. Now again, the borrower, that's the person on the deed of trust or the mortgage. And it really isn't you. It's the name of a legal fiction that you have an interest in, but it isn't you. And that could be important, why you can't find things, because you're looking in your name instead of in the name of the entity, the legal fiction that was created, that has other people involved other than just you that you don't know about. That part's my theory, and we're going to have these guys actually ferret it out, and we'll find out what it is. But this is what John Corman had to say. My name is John Corman. I, as a paralegal who lives in Florida, investigate mortgage loans for an attorney who defends clients against foreclosure. Now, this is written in like 2005, if I'm not mistaken, right? So it's already 11 years old. The job I did, I'm going to take that back. I don't know exactly when it was. 2011. That's when he put it in there. That's when it got put into here, 2011. The job I did was research the corporate trust documents, law of the case, filed with the Securities and Exchange Commission in reference to a target loan, and create an affidavit based on my findings. So the dude does his research and then creates an affidavit. He's going to swear to it. Almost every mortgage loan investigated, which was produced by a major banking institution between the years 2000 and 2008, was securitized. Securitization is the act of producing an investment vehicle of mortgage-backed securities using the borrower's mortgage note as the underlying corpus as collateral. So the first thing is, well, what's the mortgage note? Are we talking about the note that you write, or is it the deed of trust? Because there is a thing called a note, but it doesn't call itself a mortgage note. It just says mortgage, or it just says note. But securitization is the act of producing an investment vehicle, right, Well, what's an investment vehicle? Let's just think about what they just said. Hang on just a second. Shit. Okay, sorry about that. So, let's just continue on. In each and every securitized loan produced by these banking institutions, file with the Securities and Exchange Commission certain documents which are mandated, include but is not limited to pooling and service agreement, prospectus, indenture, 10K, blah, 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 blah. Reading these documents in each investigation to date, the common mandated procedure is as follows. First, we have the lender. All right, so the lender. If you were to look at your deed of trust now, I say, okay, there's the lender. Shortly after the mortgage note documents have been executed, or before the note has been executed, and that's why I think we're talking about the deed of trust, because, it just seems that we're talking about the deed of trust, not the note. But forgetting that, shortly after the mortgage note documents have been executed, the lender sells or has already sold its right, title, and interest in this mortgage note to a third party. An arm's length transaction, called a true sale, to a party known as the seller. Within 30 days or less, the seller will sell its right, title, and interest to this mortgage note to another party known as the purchaser, also identified as the depositor. The depositor agrees to trade with a named trust entity. Okay, so now we're going from a depositor to somebody called a named trust entity, its mortgage note for a predetermined amount of mortgage-backed securities. These certificates are then sold to investors. So, technically, we just got all this paper going back and forth. They're all negotiable instruments, and it's being negotiated from what you gave them into something else and given to somebody else. But what they failed to ever point out is that the lender, in the very first place, the lender never signed the loan application, and the lender never signed the deed of trust. So you never had an agreement with the lender, and all the payments that you make on a deed of trust or a mortgage go to an escrow account, to a third party, and the only reason to do that is because the other two parties haven't come to an agreement yet. And you keep paying your payments into an escrow account. But the lender never signed the paperwork. And not only that, if you take the lender's name just as it shows on the document, and it will say where it's incorporated at, we'll look at one here shortly, and you go to that state and look, you won't find that name is exactly the name that's used for any business that's registered to do business in that state. And therefore, it's a pseudonym, it's a fictitious name, and it's fraud. And so this is just, this is the fraud I'm pointing out. This dude's going to point out enough of his own kind of fraud, but it's just the way it goes. So now, a real interesting thing happens once the mortgage note is acquired by this named trust entity. Witnessed through the use of specialty licensed software which permits investors or licensed users access to any named trust entity. So I'm just assuming he has access to this so he can see what he's just talking about. Right? That they have this licensed software which permits investors or licensed users access to any named trust entity. So what he can see when he looks, I can see each mortgage loan held by this named trust entity, and I can see its current status, and I can see if the named trust entity is in possession of the mortgage note documents. I can see if a mortgage note is 30, 60, 90 days late, or if it's in foreclosure. I can also see how many tranches have been created within the named trust entity. The analogy to describe a tranche is, in my mind's eye, would be similar to, you give me one apple, I return this one apple to you as apple juice. Different form. And however, I managed to create from one apple 10 additional artificial apples out of thin air and transform them into apple juice. Now this named trust entity has authority and ability to sell juice from 10 artificial apples, right? So that's what he's calling these mortgage-based securities, mortgage-backed securities in multiples of the underlying collateral by creating multiple tranches within the said named trust entity. What is that? Within these multiple tranches, I find the same mortgage note to exist at full face value. In other words, it's been hypothecated. There was one, now there's 11. The last investigation which I completed within the last week, the named trust entity held 21 tranches of the same target mortgage note appeared in each one of those tranches. So it showed up 21 different times. This one mortgage note had the potential of generating 21 times its face value of this mortgage note in mortgage-backed securities sold to investors. Based on the foregoing, if a trust sells these mortgage-backed securities to investors and receives only 10 times the face value of the original underlying mortgage note, has the named trust entity been damaged by the mortgagor not making promised monthly payments under the mortgage note agreement? In other words, if Sam goes to the bank and borrows a sum of money, but Sally pays off the debt, can the bank still claim to be damaged party because Sam didn't make the payments as promised? Well, when you put it that way, well, no, Sally paid it, so why are you still coming after me? Well, isn't that what they did when the government bought off all the frickin' bad notes? They're already paid for. You know, they're coming after you because you're not making your payments. In the event whereby the lender knows beforehand this loan, mortgage note, will be sold outright, securitized once executed, the borrower is actually entering into an undisclosed investment contract, not a loan per se. In the not so distant past and throughout our history prior to securitization, the maker of the mortgage note holds the possessory right of the mortgage note. Once the debt was discharged, the bank which held this mortgage note was, as a special deposit, returned it to the borrower. Today, with the advent of securitization, these so-called loans, special deposits, are truly investment contracts. Mortgage note sold outright to generate profit, and the borrower is an undisclosed investor, and the borrower is an undisclosed investor, and the borrower is an undisclosed investor with possessory rights to the profits generated from the said note. It's the borrower's money. Because this undiscovered investor, the borrower, is unaware that the money due, it abandoned the right to receive said funds when borrower maker failed to make a claim to said funds within 3 years. Okay, well, let's make it today. It was fraud. How do we do it? Right? These people would know. To prove my point, the Attorney General, remember he wrote this to the 50 Attorney Generals, to prove my point, the Attorney General needs to request the servicer or the trustee to produce a copy of the 1099 OID form, which was filed with the Internal Revenue Service, and the 1099A, and including the 1099B. You need the 1099 OID, the 1099A, and the 1099B. From who? From the servicer or trustee. I wonder if this guy knows how to get those. These 3 forms are filed with the Internal Revenue Service by either the servicer or the trustee and will prove the aforementioned allegation that it is the borrower that created and is entitled to the original issue discount. But the borrower has abandoned these funds, that's what the 1099A will show, which is now claimed by the servicer or trustee on the 1099B. In other words, these aforementioned forms will identify the bank as the debtor. The profit made from the invested mortgage note belongs to the maker. We live in a wonderful place if it wasn't for the deceit. I mean, this guy just pointed out, like, okay, brother, let's go collect the debt. Who do we need to talk to? Because apparently he understands what's going on. Many of today's so-called lenders only lent their name to the mortgage loan. Well, they didn't even do that. They didn't use their proper name. That's the other thing. It was fraud from the beginning. In other words, the lender did not lend you their money. No, they did not. That's because they didn't sign the contract. An undisclosed third party provided the funds for the borrower, making it appear like the lender, bank, broker provided the funds. You're going to find out that you wrote your own, right? That's what the other note is. They took that note, as we'll see, the one that says note on it, and they deposit it within 3 days or some short time after, and then I believe they turn around and that's what they give you in a check that you endorse and give back to them at the closing table, and you think you just bought this property. And all they did is they went into your Social Security account and not securitized it, but monetized it. A group of investors or a single investor creates what is commonly known as a special purpose vehicle, a SPY, wired the money to the lender just prior to closing. Well, go figure. The lender bank, now acting in the capacity as nominal lender, used this SPY money to transact the closing. So it wasn't their money, it was this money that got wired in just before the closing. And then they write a check and give you the check. It's got your name on it. You endorse it and give it back, right? You could have endorsed it and taken it to the bank and said, here, I want to cash this. Instead, you gave it back to them. I believe that's how it works. And, that's just, we'll see if there's any truth to that. But at the end of the day, hey, these guys, he's already said that the borrower is the investor, and the borrower is the name that's on the deed of trust, a legal fiction, of which you're a creditor. So somewhere underneath that is where you show up, one level deeper. But the borrower, apparently, according to him, is the investor. Okay, thereafter, this nominal lender takes on a new role as servicer of the debt, or it may simply employ a subservicer. That could be like a trustee, right? Because it said servicer or trustee. So the servicer is going to hire somebody else and make them the trustee of the process. The borrower makes the monthly payments to the servicer, who she believes is the lender, who forwards the payments less its fee to the true lender, right, to the investors, which is the borrower. So your money is going to go to you, less the fee they're taking out. The homeowner was tricked into thinking he was a borrower of a loan when, in fact, as a seller of a mortgage note into an investment trust, right? So you're the seller of the mortgage note, and somebody else bought it, and so whatever it made is yours. The investment trust has no right to a mortgage, which is used to facilitate the purchase of a note, fraudulently procured under the guise of a loan, when in fact it was not a loan, but rather a purchase sale of a mortgage note, facilitating the foundation of these mortgage-backed securities. The true nature of this transaction was not disclosed to the borrower, neither before or at closing, and this nominal lender was paid in full, plus commission for a loan it did not fund. Can a nominal lender that did not fund the transaction, the loan, putting its name on a mortgage note, pretending to be the true lender, tricking a homeowner into signing over a mortgage note in order to secure an investment security, thereafter assigned a beneficial right to a third party, a right which it never held from the beginning? Right? It's all fraud. A reading of the corporate trust documents filed with the Securities and Exchange Commission, two constants are apparent. The original lender, after selling its right, title, and interest to the said mortgage note, becomes the servicer of this debt, and the conveyance of the mortgage note documents mandate the delivery of the original mortgage note endorsed in blank without recourse, with all prior and intervening endorsements, showing a complete chain of endorsement from the originator, the lender, to the person so endorsing to the trustee. Okay, whatever that's all about. And every investigation which I have personally conducted, so I'd like to see what piece of paper it is he's talking about, right? That would be very handy here. But regardless, in every investigation that I have been personally conducted, find that there are 4 parties to the initial transaction if we exclude the borrower. So forgetting the borrower, there's 4 other people involved. the originator lender who sells right title and interest to the said mortgage note to the seller. The seller sells the rights title and interest to the purchaser, depositor, who sells to the trustee in trust for benefit of the certificate holders. So we must somehow end up being the certificate holder. Although the named trust entity document, law of this case, mandates this chain of endorsements, I have yet to witness these endorsements on any mortgage note. Right. That all this should be, one going to the next, That's how it's. So, as he says here, you don't assign it, it's endorsed over. Rather, I witness an assignment of the mortgage that purports to convey the note directly to the named plaintiff. My understanding is a note cannot be assigned. It is endorsed from the present owner of said note and conveyed to the new owner. So there's only one way to transfer a mortgage, and that's as a endorsement, not an assignment. Instead, I'm witnessing the servicer, who was once the lender, claiming to be the plaintiff, with all rights, titles, and interest as owner-holder of the mortgage note, after selling his rights, title, and interest to the same mortgage note to a third party at an arm's length transaction, viewed as a true sale. The document mandate it to be a true sale. I'm witnessing assignments being filed with the courts assigning the right, title, and interest of the originator lender directly to the plaintiff, passing over the seller, the purchaser, and the trustee when the plaintiff is a named banking institution. The named banking institution would need to acquire this said mortgage note from the trustee in order to foreclose, not from the lender. Thus, the trustee's endorsement would be expected on the note for it to be the named plaintiff in a proper chain of endorsement. And none of that happens. Instead, I witness over and over again where the assignment of the mortgage will go directly from the source lender to the plaintiff, as there are no prior intervening endorsements showing a complete chain of endorsement from the originator, the lender, to the person so endorsing the note to the trustee. If the trustee is the named plaintiff, acting for a named trust entity would still require the endorsement for a depositor, purchaser, to the named trustee and trust for the certificate holder. You got to read this stuff over and over and over again. But what we have here is just, pure out fraud. This guy knows where it is. And so if, instead of going to court for the foreclosure, say, well, he's saying that I'm the investor. I want to cash out. Let's go get my property. Let's take the reason for the foreclosure in the first place off the table. We'll just put it in our bank account. Because, they're not foreclosing on you for the money. They're foreclosing on you because you're a tenant who's not making his payments anymore. Those are rent payments as far as the bank is concerned, or whoever's holding the legal title, which is the municipality, I believe, right? That the municipality's holding the legal title to your property, and they don't want to give it up. They never do a complete transfer of title. In my opinion, this is why there are a rash of lost note claims in the past. The endorsements are missing. However, reestablishing a note cures that problem. However, reestablishing a note you never owned, held, or possessed is a criminal act, in my opinion. Not only do I believe this act is a fraud upon the court, but it's also used in the legal system to facilitate a counterfeited financial instrument. Well, that's what they do because they're not really the court. That judge sitting up there doesn't have a certificate of election or a certificate or a commission of appointment to be a judge of the state. He's just pretending to be one. Right? They're not in the de jure state. They're in the de facto agents. And they don't have any constitutional powers. But because you check the box getting your driver's license, you put yourself into their jurisdiction and they just believe they have control over you and all your property. Sort of like the Nicolaitans, those that want to lord over you. So forgetting that, right, because you don't need to wait till you're in foreclosure if this is true. You could go have this audit done now and go claim the property. How does the investor claim his property and say, hey, I want to cash out? I've invested. I want to negotiate these certificates they're talking about into Federal Reserve notes. The homeowner who loses their home to foreclosure, 95% are uncontested, with the use of reestablished note faces the added threat that the true owner holder may appear at some future date, blah, 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 blah. However, where the homeowner does not defend their case, lack of funds or whatever, this protection, should the real party in interest appear at some future date and demand payment of the original mortgage note against paying twice, is often missing from the final order for foreclosure because the homeowner lacked legal capacity to request this protection be included in the order of the court, and the plaintiff will not do the right thing voluntarily by including this protection ex parte. If you don't ask for it, it's not going to be in there. In the event the plaintiff does not or does possess and produces the original note bearing the once wedding signatures of the borrowers, the note, must contain the endorsements of all the aforementioned parties. Otherwise, there is a clear break in the chain of title. The chain of title in every securitized document I have personally reviewed requires an endorsement from the originator lender to the seller, from the seller to the purchaser, and from the purchaser to the trustee and trust for the benefit of the certificate holders. This is in accord with each one of the documents I have reviewed, filed with the Securities and Exchange Commission. These investigations that I have personally conducted disclose that most trustees oversee dormant, dissolved, or unregistered named trust entities. Every named trust entity that I have personally investigated filed a Form 15D with the Securities and Exchange Commission, notifying all parties of its termination of registration, suspension of its duties to file reports under the Securities and Exchange Act of 1934. Well, duh. Okay, we're just going to not do it. These investigations I have personally conducted disclose that most trustees oversee dormant, dissolved, or unregistered named trust entities. Every named trust entity that I have personally investigated filed a Form 15D with the Securities and Exchange Commission, notifying all parties of its termination of registration and suspension of its duty to file reports under Securities and Exchange Act of 1934. Then what the fuck is a trustee doing? Right? He's committing fraud. Whatever was there is no longer there. They created it, and then they put in the paperwork and destroyed it. And just pretend that it's there. The trustee foreclosing on homeowner. So the trustee now, if you think about this, is the attorney firm that's foreclosing on you. The trustee foreclosing on the homeowner after filing a 15D is doing so on behalf of a named trust entity contrary to the Investment Compact Act or Company Act of 1940. See Section 7 under transactions by unregistered investment companies. That's what he's doing now. It's a transaction by an unregistered investment company because they put in the form and cancel themselves. What is really transpiring with these mortgage loans, in my mind's eye, the lender is selling the borrower an automobile the lender knows has faulty brakes. And then said lender takes out insurance policy on that automobile. Once the automobile is totaled in a crash, the lender collects on the insurance and holds the borrower liable to pay the outstanding balance due on the automobile. Look no further than the foreclosure rates here in Florida on your home state, and then look at the record profits being generated by banks. How do you think this feat is being accomplished? All foreclosures. Are foreclosures a negative force on the economy because it does not seem to be negatively impacting the major banking institution? Which brings me to my final observation. Mears, basically, which acts as a purported mortgagee of record, which we know is not true, as Mears did not loan any money to, and the borrowers do not owe any money to Mears. Mears usually acts in the capacity as a nominee for the mortgage note holder. However, according to procedural manual produced by Mears, it may only act in such capacity, nominee, for and on behalf of other Mears members. To the best of my knowledge, none of these securitized named trust entities are Mears members, thus bifurcating the mortgage and note, destroying the security and rendering the mortgage a nullity. When you get right down to it, I think we would all agree the bottom line is the creditor is the party with the skin in the game. They are the certificate holders. They are the true investors, hard money lenders. And I think that that's you in your proper name are the creditor. All certificate holders. All certificate holders. So this is the thing we're talking about now, right? It doesn't matter. It started out as a note. Now it's a certificate. Our customers is Cede and Company. Cede being the nominee of the Depository Trust Company, a subsidiary of the Depository Trust and Clearing Corp. The entities that purchase these trust certificates must purchase them from Cede and Company or from one of its authorized agents. Seems to imitate the Mears model insofar as Cede and Company appears to be a central recordation hub where investors trade positions by electronic registration. These named trust entity certificates are most always held in the street name of Cede and Company. And street name is the name of a brokerage. And so I don't know exactly what that means other than somehow all the stuff gets to the DTC. And that's where it's all registered. This is the hub. So if it's registered there, there is where we would find out, what our position is. Within the past month, I've engaged to conduct research on yada, yada, yada. So anyways, and he goes on. But you get the idea. So again, this is just what some man wrote that was put on some other man's blog. Borrower is actually entering into an undisclosed investment contract, not a loan. Okay, so now let's look at what it looks like when it's just not a generic, and we'll look at a particular. Okay, and so this is... I thank Bobby's friend Harold and his wife Leah for letting me use this. This is really, really interesting. So they paid to have a mortgage forensic securitization analysis report done when they were going through a foreclosure. And whoever did it put a gold seal on it that says mortgage forensic auditor. And I think this says Falcon. I don't remember what it said. Securitization, Falcon, we'll find one the other way and I'll look at it closer. But so the guy did it under seal. And so this is something anybody can have done. And as I remember them saying, or as Bob telling me, he went and had this done, and within a couple of days he had this report. It didn't take very long, and was less than $1,000. I think it was $900. I could be mistaken. So don't hold me to the value, just have to ask them. But it's based on the MIN, the MIN. And so let's see what we can look at here to go with this at the same time. Well, we're going to look at the deed of trust. And the note. Okay, there's the deed of trust. And the note. All right, so here's this guy's analysis. So they're using this MIN number, and the MIN number shows up, right? It's on the deed of trust. It's on the note. So I'm not exactly sure what it means, although I did see it before. Mortgage something or other. Note date active. JP Morgan is a servicer, investor with a footnote by it, not disclosed to the borrower. That's the problem. They're not disclosing the investor to the borrower. They're not telling you that you're the frickin' investor as the borrower. And this was done on MERS Service ID, which is a website. So if you were to go to this website, MERS-Service ID, servicerid.org, and did a couple of things. Like put in your MIN number, which I showed you where it came from, and then you got to, put in a code so they know that you're not a robot or something like that. You get to a page where it says, as the borrower, if you put in some more information, it will tell you who the investor is. And I don't know if anybody's tried that yet, so that'll be something that will be tried here shortly. But nevertheless, let's see what this guy had to do, because that's where he went to. One match found for this MIN, and that's what he's going to be talking about. But the footnotes. J.P. Morgan Chase Bank cannot be trustee or investor or own the note, lest it becomes a partnership with the certificate holders. The information about the investors was intentionally withheld by the securitization partners, which are violations of Federal Reserve new amendment, which is law now, and TILA. Truth in lending, I believe, is what that would be. Borrowers repeatedly request this information and were not provided. This information will expose the foreclosing parties before the court who have acted or are acting ultra vires beyond their legal capacity. If they this information, who the investor is, will expose the foreclosing parties, that would be whoever the plaintiff is, before the court, who have acted and are acting beyond their legal capacity. That would be called contempt of court. Borrower signed a promissory note and a deed of trust on 9/20/2005. If the date on the MERS system is 9/27/2005, then borrowers have a right to rescind the transaction because the 3-day notice to cancel was defective. Well, go do it today. Because this doesn't have a damn thing to do with the house. This is about the money. It's still defective. And please don't forget, the TILA is not the only source of legal support for rescission. Any common law statutory fraud, I got to go to the bottom of these things, so hang on a second. That's a footnote. State or even a misunderstanding or frustration for purposes could be grounds for rescission, including but not limited to fraud in the execution, fraud in the inducement, and fraudulent conveyances. And so these are all things about fraud. So you can't take it to the court of law because the court of law only cares about who has the legal title, not how they got it. We need to get this to the court of chancery because courts of chancery are the ones who decide when somebody got it by fraud because it would be a sin against God. And the court of chancery started out as, it was under the church. The chancellor was the king's right-hand man, and, usually it was a cardinal of the church until the Reformation, and they changed it all to what it is today. But in common law, the court of chancery were the CPAs would be, the masters is where we need to be, not a court of law with attorneys at law. We need to have the fraud pointed out first, and then they write a writ that you're supposed to take into the court of law to get executed. A forensic analysis report should state as follows. The borrowers are going through a hardship and loan modification, and Chase received about $4 billion in money, and or could that be trillion? I don't know. No. Hundreds, thousands, millions, billions. Almost $4 billion. Right, so basically, what was that money used for? That's what all this part is. But if irregularities in the modification, short sale, foreclosure process reflect deeper failures to document properly changes of ownership as mortgage loans are securitized, then it is possible that the Treasury is dealing with the wrong parties in the course of a home affordable modification program. They're dealing with somebody who doesn't have any interest in it. They gave it away, but they just act like they have interest in it. This could mean that the borrowers either received or were denied modification improperly. Some servicers, such as J.P. Morgan Chase Bank or Wachovia National Association, in this case dealing with the Treasury, may have no legal right to initiate modification, short sale, foreclosure, which may call into question the ability to grant modifications or to demand payments from homeowners, whether they are part of modification, short sale, foreclosure mitigation program or otherwise. In other words, the people asking for it don't have any standing to ask. They sold their standing. These securities have not been approved or disapproved by the Securities and Exchange Commission or any state security commission, or has the Securities or Exchange Commission or any other state securities commission. Weirdly written sentence. Therefore, the parties were selling the unregistered and unregulated security. That's the part that matters. This dude knows they're committing fraud. It's just we can't go tell the court of law. We have to go to the court of chancery. And courts of chanceries have masters. And these people are masters. They're just not special masters. Right? Special master would be somebody working for the court. So maybe they know who they are. And I just happen to think that in my county, they actually have one judge that sits in for all business type. You know, almost like what you have in Delaware, where it's all court of chancery. So, right, maybe he's a master. I got to go back closer and look at what it says for him. But nevertheless, you know, I'm talking to these people and let them figure it out. So then the relevant parties, you got the mortgage loan seller, the sponsor, the originator, the depositor, the securities underwriter, the issuing entity, yada, yada, yada. You got all these different people involved. And so, well, we'll just read it. My name is, of course, he didn't use his full name, or his proper name, because there's no M. Nawaz Raja. I have investigated mortgage commercial loans for individual borrowers and attorneys who defend clients against foreclosure. The job I did was research the corporate trust documents. This dude, he really copied and pasted a lot of what the other guy wrote. This, you know, what kind of bothers me about him, but it doesn't mean it isn't true that he didn't see these things, because he's got his own analysis. I don't want to read all this because it just takes too long. Trust documents have been executed before note is executed. Nominal lender sells or has already sold its rights, title, and interest in the mortgage note to a third party at arm's length transaction. Yada, yada, yada. Now, a really interesting thing happens once the mortgage note is acquired by the named trust entity, witnessed through use specially licensed software. I can see each mortgage note, commercial loan held by this named trust entity. I can see its current status. I can see if the named trust entity is in possession of the mortgage note documents. So he's talking about this, you know, this specialty licensed software which permits investors or licensed users access to any named trust entity. And just to go back and say, well, if you go to this site here, if you have a loan, if you already have one of these and you have your MIN number, or you can use the address, or it's got a couple of different things, you should be able to go there and find out as the borrower who the investor is. But the problem is the borrower isn't really in your name, and if this was an entity that was created without your knowledge, they may have actually given it an EIN number that you don't know exists. So what we need to do is track down who is the borrower. Where is that legal fiction registered? Because you're the creditor of that borrower. And I'm thinking he may be over in the bankruptcy court. So that'll all have to be worked out on its own. I'm just pointing out what these people said, that, look, there are people that understand that there's a fraud going on. They can show you where it is. Well, if they did nothing else, say, okay, well, if I'm the investor, I'd like to cash out. How do I do that? Right? And see if somebody asks them that, if they can tell us what to do. Because really, this is all the stuff here that I just read that he just, you know, copied and put into his own analysis. Right? But to prove my point, one needs only, right? So request the servicer or the trustee to produce a copy of the 1099 OID. Okay, so if we look at the deed of trust, real quick, who's the borrower? Right? The borrower is this legal fiction, Harold and Leah, husband and wife. The lender, Crestar Mortgage, according to what they said, has already sold its rights, title, and interest into what's going to happen. And they've appointed a trustee, this Michael A. Bosco Jr. So this dude is the guy that should have access to the 1099s they're talking about. This 1099 OID A and B, right? The servicer or the trustee. And what they had said is that because Crestar Mortgage has already sold its rights as the lender, it's going to become the the servicer. Going from lender to servicer, and it has a trustee. But apparently this guy can get, that these people can get them, so hey, have them get them for you. What does it say? Right? Because if you can show the IRS that you're the owner, well then, you got something to fight with. Okay, then he made this affidavit up. My area of expertise based upon knowledge, training, and experience is in the field of securities, the securities industry, derivative securities, security regulation, special purpose vehicles, structured investment vehicles, creation of trust pooling agreements, insurance of asset-backed securities, and specifically mortgage-backed securities by special purpose vehicles, in which an entity is named as trustee for the holders of the certificates of the mortgage-backed security. So who's the holder of the certificates? That's that's where the cash is. Them certificates need to be negotiated, because they're negotiable instruments, into Federal Reserve notes and put in your account. The trustee declaims any economic interest in the mortgage loans, the economics of securitized residential mortgage, securitization, blah, 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 blah. Okay, so the trustee disclaims any economic interest, so we should be able to go to the trustee and tell him, go ahead and sell our fucking securities. Excuse my French. Our certificates. I have knowledge, training, and expertise on various percussor asset protection strategies, including minimization of taxability, liability, which also are constructed to be made bankruptcy remote in commercial and real estate settings. Whatever all that means. I have knowledge, I have knowledge, I have knowledge. Right? It's got knowledge in the Uniform Commercial Code. Okay, well, let's think about this. The debtor isn't you. The debtor is the borrower, which is this legal fiction. So, can he do a UCC 11 against that debtor and say that you're a creditor and file and that way you would perfect your lien against that debtor? Okay, I've been asked to render opinions pertaining to our candidates here, our borrower and mortgage on a title deed of trust, property of foreclosure, securitization are in question, the original nominal lender, according to said documents, Crestar Mortgage. Right, and I say Crestar Mortgage, and that name is not registered in Virginia as a mortgage company. I evaluated the materials listed below, among other materials, facts, and data, in basing my opinions and inferences. Each of these documents and other materials, facts, and data, in my field, would customarily rely upon forming opinions and inferences. The information sources I reviewed are sufficient for me to testify the facts and opinions that are included herein. Where additional information is required to make factual statements and express opinions on further subject matter, I have so stated. the documents were presented to me by Harold and Leah. You see here, they're using West written out, where usually you see it with just a W. I have reviewed settlement papers, Security and Exchange Commission filings, various land records. I have performed independent research or searches as to securitization documents. Most of the testimony in this declaration was plainly clear for review on below listed materials, but to the extent that technical and specialized principles or methods were required, they have been reliably applied. Borrower's loan is not owned by Fannie Mae or Freddie Mac. The closing loan documents relating to the loan transaction that are subject to the lawsuit, not attached because too voluminous and others are already of record with the court. Deed of trust note are attached as Exhibits A and B. The factual results of the forensic review and analysis performed by me, which I have attached as a chart showing the path of borrower's note, Exhibit C. So let's look at that. That's kind of interesting. The flow chart he did. Okay. Yes, sir. Tick tock, tick tock. Ouch. This is the flow chart that he did. All right. Sun Alternative Loan Trust. So this is the thing that was but no longer is, right? They put in the paperwork to destroy it. But here's the mortgage company, Crestar Mortgage. And they get a loan note and they give it to SunTrust Asset Funding, the seller, who takes a loan note and they sell it to SunTrust Asset Funding LLC, the sponsor. This one is proper case, this one's uppercase. It's one like this one is a common law company and this is a statutory company or corporation, something like that. I don't know. Then it goes to a depositor. Well, the depositor never puts it into this loan trust they're talking about. Right? It says right here. Never made to the trust. Trust has no assets and no corpus of the trust. Due to major trigger event, AIG bailout, payments of insurance proceeds, the trust was dissolved and toxic assets were purchased by the Maiden Lane LLCs as per Assets Purchase Agreement, December 2008, and per agreement, March 2011. These assets were purchased by AIG as part of Asset Purchase Agreement, March 2011. Right, so nothing went here. They all went into this black hole called the SunTrust Capital Markets Incorporated Securities Underwriter. But they didn't come out. They went in as a loan, and they came out as a certificate bond. So there was a conversion of the property. And the certificate bonds went to the dealers, who went to the agents, who went to the investors. So who's the investors? And the investors are paying cash, 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 and it's going the other direction. So, right? I say that this cash came from you as the investor, and now you're paying yourself in the certificates. And other than that, you're just going to have to go have one of these people explain it to you, because I don't understand it. I'm just reading what it says. But I can tell it's saying, hey, the property's yours. Various applicable securitization documents, blah, blah, blah. We don't need all that. They're too voluminous. The investor on the loan has been intentionally hidden, and the investor in this case has chosen not to disclose this information, which is incorrect, misleading, and fraud. In the present case, Wachovia Bank National Association also is trustee of the trust, SunTrust Alternative. Okay, the investor on the loan has intentionally hidden, and the investor in this case has chosen not to disclose its information, which is incorrect, misleading, and fraud. The information about the investor was intentionally withheld by the securitization partners which are in violation of the Federal Reserve new amendment, which is law now, and TILA. Borrowers repeatedly requested this information and were not provided. This information will expose the foreclosing parties before the court who have acted and are acting ultra vires. Hey, we read that before. Wachovia Bank, National Association, agreement filed, SEC, without any specific description. Where one trustee ends, another trustee begins. It's a classic obfuscation and musical chairs. Note that Wachovia Bank, as trustee, but the usual language on the terms of certain trust dated, etc., is absent. This is because there usually is no trust agreement designated as such and no trust. In fact, as stated herein, it is merely an agreement between the co-issuer and Wachovia Bank Association, which it means that far from being a trust, it's more like an operating agreement of an LLC. There you go, limited liability corporation. That's what they made you into. That's what the legal fiction is. Some kind of LLC. The nominal lender on the note and security deed is Crestar Mortgage, which rented its name and charter to some undisclosed lender for payment of hidden fees to standing in between for undisclosed lender, which is a violation, as the undisclosed lender was not disclosed to the borrower as of today in spite of repeated requests from the borrower. Well, the borrower is the lender because you wrote a note. So here's what happens, right? You do this thing called a note. It's part of the transaction. And at some point, this note is endorsed, right, to be deposited into a bank, but there really is no name here, right? They don't, without recourse, pay to the order of somebody, and then SunTrust Mortgage Incorporated, the vice president, right? So somebody's name needs to be in here. So I don't know who that is, but that's what they do with the note, right? They deposit the note and they convert it from this note, a negotiable instrument, into Federal Reserve notes, which are also negotiable instruments. This is a private note, and it's negotiated into public-private notes, which are Federal Reserve notes. Well, once they did that, it destroyed this note, but because this note, you're the signator to it, it's your property. Because they never lent you any money, right? This is the thing. They never did the deal, so no matter what you wrote or did, well, give me back my property now. Well, they converted that into dollars. Those dollars are yours. Okay. Promissory note has no endorsement on it, whereas the note should have at least 8 or more endorsements, which are missing on the note. Reasons best known to the entities involved. There was no endorsement showing to the trust, SunTrust Alternative Loan Trust, which is an indication that the borrower's note never made it to the trust. The trust was empty, having no assets and no corpus. Crestar Mortgage, the nominal lender, SunTrust Funding LLC, the seller, SunTrust Asset Funding, the sponsor, Bank of America Funding Corporation depositor, SunTrust Capital Markets Incorporated securities underwriter, dealers, agents, and investors. And then in investors, it says Prospectus 424B, 5 stated 12/22/2005, SunTrust Alternative Loan Trust, something or other. Right, it's a little bit too hard for me to follow. But they're the expert. I just need to know, well, where is it? It's mine, and how do I claim it? The true sale is from depositor to securities underwriter and not to the trustee, Wachovia Bank National Association. So that's interesting. The true sale is from the depositor, which is the Bank of America. Right? So the true sale happened here from these people, Bank of America, the orange. Where is it now? Okay, true sale, jeepers. 2, securities underwriter, SunTrust Capital Markets. I gotta close some of these things. Which one am I looking for? This thing here. SunTrust Capital Markets. This is where the sale happened. Whatever the sale was happened here. It really didn't happen up here. This is where the sale happened. Okay, and not the trustee, Wachovia Bank National Association. The name of all the above parties are not there on the note, except the nominal lendar, Crestar Mortgage. And no endorsements were done to the seller, sponsor, depositor, and to securities underwriter. The note never made to the trust, and there was no endorsement in the name of the trustee, Wachovia Bank National Association, or trust. SunTrust Alternative Loan Trust Series, whatever. Therefore, the assets never made it to the assets of the trust. Well, then where did they go? The note was not previously endorsed as required by the pooling and servicing agreement. So all these things didn't happen, and by the way, the lender never signed the deed of trust. They didn't sign the loan application. All your payments went to a third party. They never went to the bank. They went to somebody else. And that's your property. So, we got to find out where the escrow account went to. And that would be something to ask them. Well, where it happened to the escrow account? Because the payments didn't go. When you're making payments, look at your payment book. They're not going to the bank. They're going to an escrow company. At least that's how I remember it. I haven't owned property in a long time. I believe that to be correct. You're just going to have to go look. So, anyways, this thing he wrote is quite long, and I'm not going to try to read it all, because what we need to do with what we have is go ask a few more questions. But I do want to show you where it said on, I think it was this one here. Sorry it takes so long to do this. We might all fall asleep waiting for my computer. Come on, computer. Work with me. I shouldn't complain. It still works. Thank you, Jesus. So what was it that he said that I saw? It's like, well, that's what we need to do. So I may do another video just on this next part here, right? But for right now, the investor is still the creditor. If the investor has not sold, transferred, or alienated the hybrid mortgage-backed security, and if the investor has not directed or indirectly paid, not been directly or indirectly paid through the credit default swaps, with or without subrogation, or paid through federal program with or without subrogation. So, right, somehow the creditor could still be paid by these ways, it sounds like. Since no such instruments appear on record, any right of subrogation would appear to be equitable. Any right of subrogation, right of subrogation. I have to see what that is. I believe we have that. That would appear to be equitable, and we like equity. Equity just means it's equal, right? Equal protection of the law. Thus, for purposes of this declaration, the unknown and undisclosed investors constitutes the only creditor presumed to exist until the undersigned is presented with contrary evidence of the type that an expert in my field of expertise would normally take into accounting in forming opinions and conclusions. Well, who is the investor? Therefore, I conclude that if there remain any creditors pursuant to the note signed by Harold and Leah, then they are the unidentified investors and all other parties, including Wachovia Bank, National Association, J.P. Morgan, or disinterested, or I think it should be are disinterested. In other words, there's only one person interested, that's the creditor. We need to be the creditor. The borrowers have made unsuccessful attempts to obtain from these entities and others the identity of the lender, the documentation authenticating the identity of the lender, and an accounting from the lender as to all money paid or received in connection with subrogation obligation. Neither affiant nor these entities nor the court will be able to determine the amount of the borrower's equity in the property until a complete accounting of all debts and credits, including but not limited to the third-party payments referenced above. So you tell them, dude, go get all the accounting of all debts and credits, and I'll pay you when you get me a check. Until such times the requirements for said documents have been answered, I will be unable to identify with certainty the exact identity of the current creditor, meaning the true owner of the alleged obligation, other than to say that it is not the nominal lender, Crestar, selling to and being paid by SunTrust Asset as seller, SunTrust Asset Funding, LLC, as seller, selling to and being paid by SunTrust Asset Funding, LLC, all caps, as the sponsor, and the sponsor selling to and being paid by Bank of America, the depositor, and the depositor selling and being paid by the SunTrust Capital Markets, the underwriter, selling and being paid by the dealers selling and being paid by the agents, and selling and being paid by the investors, right? Wachovia Bank, National Association as trustee in a series of securitization transactions pursuant to pooling service agreement as servicing and mirrors are the parties who own funds where the risk and the outcome of the litigation, therefore none of these were the real parties of interest. So all them people he just mentioned are not the real parties of interest. Well, where did he start? He started with Crestar Mortgage. Well, there was one person involved before that, and that was the borrower, which is a legal fiction for which you are the creditor. So we need to be seen as the creditor, not the borrower, but the creditor of the borrower. And because other people didn't sign the contract, there is no contract, then we just want to go ahead and rescind the thing, and we're not going to do the deal. Give us back our property. These investors were not named. The practice has been intentional, in my opinion, based on overwhelming commonality of this obvious reoccurring, obvious failure, and other overwhelming evidence, the third-party sources, that could conceivably lose because they would have paid value prior to default or notice of a default and fall within one or more of the following classifications. Insurers that are paid some part on behalf of said investor. Now again, your insurance company and your mortgage insurance, they say that they guarantee your title in fee simple. Then we should be going to the insurance company and putting in a claim because you have a warranty deed that says that you're just a tenant. I don't know how that fits into this, but maybe that's a trail he can follow also. How many different kinds of trails of individuals and corporations can he track to find out where they actually are, what they're actually doing, and what's your interest in any of them? I don't know that I want to read any more of this. I'm done. That's all I'm going to do for now. Just to give a flavor that, I think that if you have a if you're in a foreclosure, or if you're not in a foreclosure, you want to have this forensic audit done on the deed of trust and everything that goes to from the position that you know that you are the creditor to the borrower, and the borrower is not you, it's a legal fiction. You want them to find the legal fiction, find out where it's been registered, find out all they can about it, find out all they can about your funds as a creditor, where they're at, and that you want to get a check. And if we need to go to the Court of Chancery, well, let's go there. So somebody with an CFF, right, that's what this person has. Now, I don't know that this gentleman has that, but, you know, he's got puts a seal on his paper, says he's that says he is who he says he is. Right? He did it. He did this as an affidavit, acknowledged, subscribed, and sworn to. So he believes everything he said. Put a seal on it. So he knows he's the bean counter. He knows where the beans are. We just need to go figure out, well, what piece of paper do I need to sign to get my beans? And he said 1099 OID, 1099A, 1099B. Those three documents will show who the investor is. And those come from the, let's go back and find it. Right, to prove my point, the Attorney General or you asking someone who can, such as one of these people, to go do it, request the servicer or trustee produce a copy of the 1099 OID form, which was filed with the Internal Revenue Service, the 1099A, including the 1099B. These three forms are filed with the Internal Revenue Service by either the servicer or the trustee and will prove the aforementioned allegations that it is the borrower that created and is entitled to the original issue discount, but the borrower has abandoned these funds on a 1099A, which is now claimed by the servicer or trustee on a 1099B, although you never signed any of those pieces of paper. In other words, these aforementioned forms will identify the bank as the debtor. The profit made from the investment mortgage note belongs to the maker, and the maker is the borrower. And so it does have to do with these forms, 1099 OID, 1099A, 1099B. We don't need to fill them out. They've already been filled out. We need to go get that evidence. And I'm just saying, man, go find one of these people and let's just take it one step further. And so that's what I hope to do with these folks here, Harold and Leah, I believe it was correct, who I got this information from Bobby in Arizona. Thanks for Bob for remembering these things, right? All these little details. Hey, he knows somebody who did this, right? We were talking about it, so I know somebody that did that. And sure enough, now we're looking at the paperwork, and it's like, oh, they're saying it's fraud. So if they're going to say it's fraud, then how do we get a remedy when it's fraud? And he calls it a rescission, right? Because the deed of trust on 9/20 and went to the mirrors on 9/27, then the borrowers have a right to rescind the transaction because 3-day notice to cancel was defective. That's all you need. I want to rescind and cancel. Let's go do that and have them return my securities. That's all we're going to try. All we really have to do, and it's all based on this MIN number, which you'll find on your deed of trust and your mortgage note. Okay, I'm going to leave it there, and we'll have more on this later. But it's a good place to start. You all have a great day now. We'll see ya.